Good morning. The committee will come to order. Without objection, the Chair is authorized to declare a recess of the committee at any time. As I said last night late for many of you, and I say again this morning, the Oversight Committee exists to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. It's our job to work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. This is our mission, this is our passion, and this is what we are here for today. The committee meets today to continue our effort to get to the truth about the IRS's targeting of conservative groups. Last night we heard testimony from the Commissioner about how and why the IRS came to not save and, in fact, to destroy the disk drive that contained emails of the now well understood and criminally charged by the House former head of the exec organizations, Lois Lerner. And I say that again. Lois Lerner has been referred for criminal charges, multiple criminal charges, by the Ways and Means Committee and held in contempt by the full House. Her disk drive is missing. His testimony included a number of significant admissions and facts. For example, the Commissioner testified that he has seen no evidence that there was any attempt in 2011 to retrieve 6 months of lost Lois Lerner emails from backup tapes or, in fact, from the main hard drive of the server. He testified that he does not know who at the IRS was involved in leaking the knowledge about Lois Lerner's emails to Treasury and onto the White House. He further testified that he did not believe leaking to the White House was a problem because the White House itself does not leak information. We'll chalk that one up to naive, not perjury. He testified that because he does not know what was in Lois Lerner's email, he has no grounds to believe they contain Federal records. While I appreciate his time and effort, our relationship with the IRS and the Commissioner was not improved by his disappointing performance. In fact, one of the most troubling portions of his testimony was to tell us that someone who he could not name who worked for him had told him sometime in the entire month of April, not the 1st of April, not the 15th of April when we all have to pay our taxes, and not the end of April, but just sometime in a 30-day period, someone he could not remember had told him one of the most important pieces of information any of us could imagine, that thousands, tens of thousands, or perhaps more emails of Lois Lerner were gone forever. I hope the witnesses before us today can help us understand further how we can have an agency that expects all Americans to maintain critical documents for at least 7 years, and in fact, the agency itself systematically destroys records after 6 months. They are worried about data integrity for a catastrophic event, but not for criminal wrongdoing of their own employees, not for waste, fraud, and abuse within the agency. This is an agency the Commissioner was sent to fix. This is an agency that had lavish partners and did not even live up to the requirement for tax filing by its own members when it held a party complete with a very expensive video at Disneyland. This is an agency that targeted conservatives for their political beliefs, that asked them for who their donors were and whether they said prayers at the beginning of an event. what they did in every way and held out their application for 501c4 like a carrot, never informing them that even the President's 501c4 wasn't registered. Today, the committee will hear testimony from Jennifer O'Connor, a former IRS attorney who directly managed the IRS's production, or lack thereof, of documents to this committee and others. During a transcribed interview last year, IRS Chief Counsel William Wilkins testified that Ms. O'Connor was one of the two key supervisors overseeing the IRS's response to congressional oversight. In fact, Ms. O'Connor was hired by the IRS for the sole purpose of overseeing the agency's response to congressional investigations of the targeting scandal. From May 2013 to November 2013, Ms. O'Connor led the IRS's response to congressional oversight of the IRS's targeting of conservatives. In May of this year, Ms. O'Connor was promoted to the White House counsel's office to work on responding to all congressional oversight across the entire administration. The IRS supposedly has spent $10 million in its response to Congress. I am hoping Ms. O'Connor will enlighten us about how the IRS spent so much of the taxpayers' money, but supposedly took them over a year to realize 2 years of emails from the most critical witness had gone missing, and in fact, that same year since she first took the fifth. The idea that the IRS just didn't notice is without believability. We will also want to know from Ms. O'Connor how the White House came to have insider knowledge about Ms. Lerner's missing emails, and more broadly, what role the White House plays in this investigation. Today, we will also hear from the Archivist of the United States, David Ferriero, about the rules and regulations for preserving Federal records. These laws include the Federal Records Act that were put in place precisely for the purpose of preserving important Federal records. In particular, I want to ask the Archivist about one claim the Commissioner made last night. The Commissioner said the IRS did not report a loss or destruction of Federal records because there is no way to know what was in Ms. Lerner's missing emails. But in fact, we do know some things about where that were in Ms. Lerner's lost emails. We know that from 2010 email correspondence we found at the Department of Justice that Ms. Lerner sent over 1.1 million pages of a database to assist the possible prosecution of those same groups that were targeted, and that information included 6103 personal identifiable information, including donors. I am hoping the Archivist can offer an opinion about whether such correspondence and documents are in fact covered by the Federal Records Act, and whose loss and destruction would and should have been reported in 2011. The hearing today continues the committee's oversight efforts of the IRS's targeting to get to the basic answers for the American people. The committee will continue to aggressively search for answers about how and why the IRS allowed to be destroyed Lois Lerner's emails. This information is critical to the committee's investigation of the IRS targeting of conservative organizations. I might add in closing, the Archivist is a welcome friend of this committee. The archives fall within our primary jurisdiction. We take great pride in the work that the National Archives does. Just last night, very proudly, I showed to the Commissioner and put in the record a little piece of history of General Jackson demanding that his government in 1803 return some of the tax revenue taken from him for a liquor that could never be produced because it is still burned. That is a piece of history that was not covered by the Federal Records Act, but because of the unique work that the National Archives does, often with volunteers from around America who come and study and research. We know what we did not know then and would have not ever demanded to store. So I would say here today to my ranking member and to all the members of the committee, the Federal Records Act is a minimum of what must be stored, but there can be no limit to the maximum of what will benefit generations unborn if we can preserve a greater amount of documents with the massive capability that our electronic era gives us. With that, I recognize the ranking member.
Good morning, and I welcome the opportunity to hear this morning from the archivists of the United States about outstanding challenges at Federal agencies with electronic records retention. During the Bush administration, the Federal agencies admitted to losing millions of emails related to ongoing congressional and criminal investigations, including the U.S. Attorney firings and the outing of covert CIA agent Valerie Plame and a host of other matters. Our committee played an integral role in investigating these problems. Representative Henry Waxman, our former chairman, engaged in a constructive effort to find solutions to these challenges. He hosted monthly meetings with the archivists and the White House Counsel's Office to monitor progress in implementing recommendations. I believe the archivist would agree with his predecessor that those meetings served a useful purpose. Today, the White House system automatically preserves emails from all employee email accounts. Since 2008, there's been additional progress. On November 28, 2011, President Obama issued a directive to agencies managing Federal records. The President also directed the archivist and the Director of the Office on Management and Budget to craft a modernized framework to improve agency performance and begin managing email records in electronic formats by 2016. I look forward to hearing a status report on these efforts. Also, the archivist, Mr. Ferriero, will give us his view on legislation I introduced last year, the Electronic Message Preservation Act, which would require Federal agencies to preserve email records electronically. The committee voted on a bipartisan basis to approve my legislation, but it has languished since then, and the Republican leaders have declined to bring it to the floor for a vote. Although today's hearing could have the potential to help improve agency systems for managing electronic records, I was dismayed last night that Chairman Issa issued a unilateral subpoena to compel Ms. O'Connor to appear here today. Today's hearing title is, and I quote, "Lois Lerner's Missing Emails," end of quote. It is true that Ms. O'Connor used to work at IRS. She worked there from May to November of last year. The problem is that Ms. O'Connor left the IRS 7 months ago in 2013, well before these recent discoveries about Lois Lerner's emails. As Commissioner Koskinen testified last night, IRS officials learned there was a potential problem in February of 2014, and it was not until May of 2014 that they understood the scope of the problem, completed their investigation, and determined the extent to which emails were available or not. Ms. O'Connor left the IRS before any of these discoveries occurred. So why is she here? According to the chairman's own press release, it's not because of her old job, it's because of her new one. She currently works at the White House Counsel's Office. She's worked there for less than a month, 1 month, but apparently that's enough to warrant a subpoena from the committee. Last night, the Republicans demanded to know when the White House first became aware that the IRS was having difficulty locating Ms. Lerner's emails. I'm sure my colleagues will repeat those questions today over and over and over and over again. But we already know the answer. The White House sent a letter to Congress on June 18th, and it said this, and I quote, "In April of this year, Treasury's Office of General Counsel informed the White House Counsel's Office that it appeared Ms. Lerner's custodial email account contained very few emails prior to April 2011, and that the IRS was investigating the issue and, if necessary, would explore alternate means to locate additional emails," end of quote. That was in April, but Ms. O'Connor did not start her job at the White House until at least a month later. I ask unanimous consent to enter this June 18th letter into the record.
Without objection, so ordered.
Today's hearing is not about policy. Today's hearing is not about policy or substance. It's about politics and press. Today, Ms. O'Connor will join the ranks of dozens of other officials during Chairman Iss's tenure who have been hauled up here unnecessarily without a vote, without any debate, as part of a partisan attempt to generate headlines with unsubstantiated accusations against the White House. Regardless of how many times the Republicans claimed the White House was behind the IRS actions, there's still no evidence, none, that the White House was involved in any way with screening applicants for tax-exempt status. No one of the 41 witnesses we have interviewed has identified any evidence of White House involvement or political motivation. Not one. And the Inspector General has also, by the way, who was appointed by President Bush, has also identified no evidence to support these baseless claims. Issuing a subpoena to a White House lawyer does not change that fact. I sincerely hope that today's hearing will focus on a serious examination of the long-standing and widespread challenges of retaining electronic records and on constructive solutions. And I anxiously look forward to the statements of our witnesses. And then with that, Mr. Chairman, I yield back.
I thank the gentleman. Members may have 7 days to submit opening statements for the record. It's now my pleasure to welcome our panel of witnesses. Ms. Jennifer O'Connor is an attorney currently in the Office of the White House Counsel, and prior to that, as Mr. Cummings said, worked as the primary deliverer of discovery to this committee while at the IRS. The Honorable David Ferriero is the Archivist of the United States at the National Archives and Records Administration. Additionally, Mr. Ferriero has asked that he be accompanied by Paul Webster, the Chief Records Officer at the National Archives and Records Administration, and as I understand, and I ask unanimous consent that he also be allowed to join the panel and answer questions, and he will be sworn in. And my understanding for all of us is that, in fact, Mr. Webster is the man most knowledgeable of and working with the CIOs throughout government to ensure that the Records Act, or the Federal Records Act and Presidential Records Act, are adhered to, and as a result is in fact, and Mr. Ferriero, I appreciate your bringing him, the man who probably knows the most about what has been asked of government and what government could and should deliver and at what budget. So with that, I would ask that you all please rise pursuant to the committee rules and take the oath. Please raise your right hands. High, please. Thank you. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. Let the record reflect that all witnesses answered in the affirmative. For those who have not testified here before, there is a 5-minute clock in front of you. I do not gavel people at 5 minutes, but I would ask that as you see it go yellow, you summarize. As you see it go red, bring it to a conclusion as quickly as possible. Ms. O'Connor, please give us your opening statement.
Chairman Issa, Ranking Member Cummings, and members of the committee. My name is Jennifer O'Connor. I'm an attorney by training. I practiced for many years at the law firm WilmerHale, where I managed large, complex litigation matters. On May 30th of 2013, I joined the IRS as counselor to Acting Commissioner Werfel. I left that position on November 30th of 2013. I understand the committee is interested in my time at the IRS, and I look forward to answering all of your questions today. Thank you.
Thank you. Mr. Ferriero.
Chairman Issa, Ranking Member Cummings, and members of the committee, thank you for this opportunity to provide testimony on maintaining email records in Federal agencies and NARA's response to the recent reports regarding the alleged unauthorized disposal of email records at the IRS. Accompanying me today is Paul Wester, the Chief Records Officer of the United States, government, and a member of my senior management. First, concerning the reported unauthorized disposal, Federal agencies are responsible for preventing the unauthorized disposition of Federal records, including their unlawful or accidental destruction, deletion, alteration, or removal from Federal custody. Agencies should carefully monitor the implementation of approved record schedules to prevent such unauthorized destruction. In accordance with the Federal Records Act, when an agency becomes aware of an incident of unauthorized destruction, they must report the incident to us. The report should describe the records, the circumstances in which the unauthorized destruction took place, and the corrective steps being taken to properly manage the records in the future. If we hear about the incident before the agency has reported it, we will notify the agency and request similar information. The goal of this process is to ensure that the circumstances that may have led to the loss of Federal records are corrected and not repeated. NARA learned of the alleged unauthorized disposal of the IRS records through a letter dated June 13, 2014, from the IRS to Senators Wyden and Hatch. In this letter, the IRS reported the loss of email records of Lois Lerner, the former head of IRS Exempt Organization Division, dating from 2009 to 2011 as a result of the failure of a hard drive. Accordingly, NARA asked the IRS to investigate the alleged disposal of records and whether it was broader than was reported in the June 13, 2014 letter. As is typical when we send a letter such as this, we asked for a response within 30 days. On a daily basis, NARA staff and records and information professionals in each Federal agency work to ensure records management policies and practices meet the needs of the agencies, protect the rights and interests of the government and its citizens, and identify the permanently valuable records that document the national experience. In November 2011, the President issued a memorandum on managing government records, which resulted in the Archivist of the United States and the Director of OMB issuing the Managing Government Records Directive in August 2012. It has two high-level goals. First, to require electronic record keeping to ensure transparency, efficiency, and accountability. And second, demonstrate compliance with Federal records management statutes and regulations. There are a number of activities associated with each of these goals, but the two major actions are, by the end of 2016, Federal agencies must manage all email records in an electronic format. And by the end of 2019, all permanent electronic records in Federal agencies will be managed electronically to the fullest extent possible. The effective management of email is a central animating issue for the National Archives as we work to meet the requirements of the directive. To help agencies meet the goal of managing their email in electronic form by the end of 2016, NARA has issued updated email guidance known as Capstone. NARA developed the Capstone approach as part of our ongoing efforts to evaluate how agencies have used various email repositories to manage email records. It provides agencies with a workable and cost-efficient solution to email records management challenges, especially as they consider cloud-based solutions. It also offers the agencies the option of using a simplified and automated approach to manage email, as opposed to either print and file or click and file systems that require staff to file individual email records. The Capstone approach allows for the capture of records that should be preserved as permanent from the accounts of officials at or near the top of an agency or an organizational subcomponent. An agency may designate email accounts of additional employees as Capstone when they are in positions that are likely to create or receive permanent email records. Following this approach, an agency can schedule all of their email and Capstone accounts as permanent records. The agency should then schedule the remaining email accounts in the agency or organizational unit which are not captured as permanent as temporary, and preserve all of them for a set period of time based on the agency's needs. The Capstone approach is part of our initial effort in providing assistance to agencies to enable them to meet the email records requirement in the directive. We will continue to provide additional information and guidance as we strive to meet all of the directive's mandates. Thank you for the opportunity to appear today. Mr. Webster and I look forward to answering your questions about Federal records.
Thank you. Mr. Webster, I understand you don't have a formal opening statement, but in order to set the tone for the committee, if you would briefly tell the committee about what your relationship is with CIOs, how you are working with them, how you are working to hit the deadlines of Capstone on behalf of the archivist, and of course, the nature of how you receive documents to the best of your knowledge from Treasury and the IRS today, including the documents such as the ones we are discussing. If you could set the stage, I think that is a good nonpartisan way to begin.
Okay, thank you. I work with 100 staff members here in the Washington, D.C. area and around the country to provide records management assistance to all Federal agencies across the government, of which there are about 250 active agencies that we work with. The staff that works on records management policy activities at the National Archives works with the CIO Council, the Records Management Council, and other councils across the government to identify different ways that we need to approach this records management, electronic records management challenge. What we have been doing since the implementation of the directive back in August of 2013 is working with all of the different agencies across the government to figure out how we can meet the two deadlines that David outlined, which is by the end of the decade, ensuring all agencies are managing their permanently valuable records in automated ways, and also making sure that email records are being managed in automated ways, both temporary and permanent emails, by the end of 2016. So there's been a number of different activities which I can answer questions about as we go, but we work very closely with agency records officers across the government, including at Treasury and the Internal Revenue Service, so that they understand where we are trying to go with electronic records management as a government and understand what their obligations are with the Federal Records Act and the directive itself, and how we try to bring those two things together to make effective records management work across the government.
Thank you. I will now recognize myself for a series of questions. Mr. Ferriero, last night we finished late, so I wasn't able to get to Best Buy. But 2 days before, I needed to acquire a storage device, so I spent about $150 and bought a 3 terabyte hard drive for about $149 plus sales tax. The IRS Commissioner last night told us that it would cost about $10 million if he was going to maintain the kind of data that we were interested in. The 80 or so depositories, as I understand, would have been a fraction of 3 terabytes, a fraction of $149 if they were simply moving them to a single NAS and then backing that up. So I guess, Mr. Webster, it may be more your bailiwick, but is it true realistically that a few $100 drive and then a duplicate of that drive realistically would be able to hold all of the data that those 80 depositories typically set aside as important permanent documents?
So, Chairman Issa, I think you identify one part of the larger records management challenge that we have to deal with, which is being able to store and preserve email and other electronic records. And as you identify, the costs of doing this are coming down tremendously, and that is not the huge factor within the issue that we are talking about. The issue that agencies are confronting is that they need to be able to organize that data and be able to provide access to it, which is separate from the storage piece. And that is where there are additional costs that agencies need to incur to be able to do that. Having said that, a lot of agencies, to be able to be responsive to FOIA requests, to be responsible to committees like this one, to be responsible for other kinds of requests and business needs that they have to develop search capabilities to be able to access those materials that are on those drives. And so that is where some of the complexity and the cost starts to add up. So as agencies are doing that kind of procurement anyway to be able to support their business needs, We believe that approaches like the capstone email approach allow agencies to be able to do that effectively.
Thank you. Mr. Ferriero, there's a document that you can put up on the board dated October 6, 2010, in which Lois Lerner sent about 1.1 million documents, including personally identifiable 6103 information, to Department of Justice in order to aid potential prosecution. Have you viewed that email?
Yes, I have.
Would you say that that is a record under the Federal Records Act?
Not having access to the record schedule that was created by which this message was created, it is an email that is record. Whether it's a temporary record or a permanent record, I can't tell.
But when the Commissioner said that, in fact, he didn't know if the lost emails, of which this is one, included items covered under the Federal Records Act, he was mistaken. Is that correct?
All I can say is that if it was created, from what I read, it is a record. What I can't tell is whether it's a temporary record or a permanent record.
Okay. Lastly, this committee has jurisdiction over FOIA. Is it reasonable to destroy, after 6 months, data routinely so that a FOIA request simply goes to data that isn't there any longer? If you want to know what was said or done, if it doesn't happen to have been maintained by choice, it is gone at the end of 6 months at the IRS.
That's right.
So FOIA requests essentially to the IRS are pretty useless, and we now know at the FTC, for example, it's 45 days. Is that, in fact, in the best interest of freedom of information, in your opinion?
There again, if it was a permanent record, then it is not best practice.
Mr. O'Connor, you declined to come here voluntarily, so we subpoenaed you. Clearly, you are not pleased to be here, but it is important that you are here. You were at the IRS and hired when we began our investigation and requested selected documents of Lois Lerner in May of 2013. Is that correct?
I started on May 30th.
Okay. So they hired you as soon as we said we want a bunch of documents, correct?
Mr. Werfel, who was the acting commissioner.
Just yes or no, please. You're a hostile witness. Yes or no. Were you hired?
I'm not
There'll be
at
order.
all a hostile witness.
Well, yes, you are. So you were hired in May. In June, when we were not getting delivery, we went and subpoenaed. In August, you were at the IRS. Is that correct?
I was there in August.
In August of 2013, we requested all Lois Lerner emails, and not any selection, not any limited group. Are you aware of that?
Yes.
And what did you do to determine the envelope or the window of all at that time in August of 2013?
So can I explain the process a little bit? I think it would help to.
Well, my time is technically expired, so I would just ask that you be full and complete in, wait a second, okay, just full and complete in what you did from August until the time you left to secure all the documents, please.
So I think a little background is helpful. When I arrived on May 30th, the IRS had a team that was already in place collecting materials and beginning to respond to the congressional investigations. I joined at Mr. Werfel's request to be his counselor and perform a number of different things, a piece of which was helping to respond to the 4 different congressional committees and the IG and others who were seeking materials. And so I played a role that was a liaison to him. His direction was to be cooperative and try and gather and produce the materials as quickly as possible, and also to be a liaison to your staff and the staff of the other committees who were interested in figuring out how they could get their priorities to them as quickly as they could. And by that, what I mean is identifying the employees whose materials they wanted to see first, and using search terms in order to identify the documents at interest. The reason search terms were necessary, as opposed to just turning everything over wholesale, among others, as I know you know, is there's a statute called Internal Revenue Code 6103, which is it's a criminal statute passed by the Congress that requires the IRS to protect taxpayer information. And the way in which they do that in situations like this is they have to read every single document to see if there's taxpayer information in it, and then redact it if necessary before producing it. So a big piece of the effort was to figure out how we could move information as quickly to the congressional committees and move them what they were looking for. So in May, what that amounts to is when I arrived, Ms. Lerner's material had already been collected, as had some other employees' materials. There was more collection that went on after that. And the process, as they explained it to me, and I'm not a tech expert, but the IRS's material is protected with careful encryption, and so it needs to be processed before it can be reviewed. So they have to load it and then flatten it and then decrypt it, and the decryption, I was told, creates errors sometimes. Then they have to do it again. And in that piece of the process, which is the first piece of the process, they would run the terms that the congressional committee staff had identified over the material, and then once that was done and the material was viewable, they would move it over into a review tool. And when I first got there, one of the things that I was doing was talking about how in order to move the volume quickly, we would need to add people, because the IRS had never encountered something like this, didn't have staff in place to do this kind of a document review and production. In addition, the technical infrastructure wasn't really there to support it, so we had a lot of issues that we had to deal with in terms of adding servers and adding capacity and you know, having technical experts deal with the systems so that it would be stable. When we got to August, which is I think where your question was, you did express an interest in all of the emails. We were at that point already sort of well into a process that had begun in May with Ms. Lerner and everybody else's emails that had been loaded at that point had been loaded with all of the terms. And so they were being reviewed. And so the staff who were working on this day to day continued to review all of that material. It was Mr. Werfel's intention that as soon as we got all of that done, we would circle back and make sure the subpoena was complied with. And I left in November. We were still in the process of the rolling production. It wasn't finished yet, but it was certainly my understanding, and I believe it to be true. I have no reason to think it's not true, that they intended to continue to produce information. But the difference between the selected Lois Lerner information and all of Lois Lerner's information comes from the fact that initially the process was organized around material that was had search terms applied to it versus the material at the end. I hope that sort of lays that out clearly.
I just want to summarize to go to the ranking member. So in August of 2013, your testimony is that when receiving a subpoena and explicit instructions that this was our highest priority, that we wanted all the emails of the person who took the fifth in front of this committee and who in fact was not cooperating and who indications was at the center of this targeting of conservatives, the decision was made to get to it after you got done with all the others. So when you left the agency, they had not yet done the extensive search. They had not yet looked for all of her emails, and as a result, that's why we go until April of this year before we discover that all her emails were never to be found.
So I wasn't there when the discovery of the lost emails occurred, so I can't really speak to that from my personal knowledge.
Yeah, that's where I was saying that on the day you left, they had not set out to discover all her emails, but in fact had not complied with the subpoena in the sense that they had not gathered all of her emails, that they were waiting until they got done with all these other things they wanted to do, and then they would go look for all of the emails.
I'm sorry, that wasn't what I meant.
Well, I'd like to know what you meant, because obviously they didn't know they were missing in the months that you were there after a subpoena asked for all of them. And I appreciate that you told us in great detail, and I appreciate that it helps us all understand. You told us in great detail about the process that you went through, but of course the process you went through was a process that you determined that you wanted to go through. We issued a subpoena, and 6103 redaction doesn't take the place of your gathering all of that. TIGTA was entitled to receive all of her emails without redaction, and so was Ways and Means if they chose to receive it.
Right. I believe that I understood, it was gathered before I got there, but my understanding from the team, and I didn't interact with them directly, but my understanding from the team who did gather it was they gathered everything that was there. And so in the process from the point at which I got there to the point at which I left, the team who was working very hard on being able to get you material was reviewing and processing and redacting as necessary all the material that had been loaded and to which the search terms that your staff and the staff of the other committees had identified. The process, I wasn't there when the process of going back to look at the ones that had originally been loaded but hadn't hit the search terms were reviewed. But when I left, my understanding was that that was something that was going to continue because the agency seemed fully intending to continue to comply with your subpoena, and I have no reason to think that it didn't.
Thank you. Mr. Cummings.
Thank you very much. Ms. O'Connor, let me ask you this. You were at IRS for about 6 or 7 months from May to November of last year. Is that right?
6 months from May 30th to November 30th, sir.
And you said, I was wondering when you came in, what instructions were you given with regard to production of documents? In other words, what did Mr. Werfel tell you were his priorities, and what were you instructed to do? I'm just curious.
His strong imperative was that we gather and produce everything that the congressional investigators and the Inspector General wanted. And he wanted it to be done as quickly as possible. He was interested in being completely transparent. And the directives he gave to me, one of my roles was to sort of be his liaison to the team that was working full-time on the document production. And in that capacity, one of the things I tried to do and worked on doing was to help them to get stuff out faster, to review faster, so that more volumes of the material that the committee was looking for, and it's 4 committees actually, there are 4 different committees, 4 different investigations, but he wanted to be able to get all of it to the investigation staff and committee members, in part because the IRS had been asked by the Inspector General not to conduct its own investigation, not to interview witnesses, so the investigative activity was happening in the congressional committees and at the IG, and so it was important to get them all that material. That's what he told me to do, and that's what I worked with the team on doing.
And is that what you tried to do?
It's very much what I tried to do.
And so you left in November, is that right?
Yes.
Of 2013. So you were not there this past February when the IRS first identified potential issues with Lois Lerner's emails. Is that right?
That's correct.
You said something that was very interesting. You said when you got there, Ms. Lerner's information had already been collected. Is that what you said?
Yes, that's correct.
And what does that mean?
Well, to my understanding, and I didn't directly interface with the staff who did this, but professional long-term IRS staff went to Ms. Lerner's computer, took the hard drive and imaged it, took the emails that were on it, made copies of all of that. My understanding is that a set of staff, and again, it happened before I got there, but so this is my understanding, also went through her office to collect any paper copies that were, I think they collected probably everything, and then went through it to find out what was responsive.
So they actually went through her office, to your knowledge, to try to find paper copies?
To my knowledge,
in addition
yes.
to everything
else.
else?
I want to clarify that I didn't witness it. I wasn't there, but that's what I was told.
I see. And so let me ask you, did you feel that you were able to carry out the instructions of Mr. Werfel? In other words, you said he told you to do things quickly, he told you to be transparent, and he told you to, that's what you told him, but did you do that?
We did our best. I mean, there were hurdles with the technology, and we had to add resources, we had to add staff, we had to add technological resources, and so I think nobody thought it was as quick as they would have liked, but we worked very hard to get the material to the committees as quickly as we could.
Now, you were not there in April when the Commissioner learned that some of Ms. Lerner's emails might not be recoverable. Is that right?
I was not there in April, no.
You weren't even working at the IRS when Mr. Koskinen was Commissioner. Is that right? Were you there at any time that he was there?
No, we didn't overlap.
Did you? So you never worked for him?
No.
And how long have you worked at the White House?
About a month. I just got there.
You just got the job.
Yes.
So, Ms. O'Connor, Congress received a letter from the White House last week on June 18th and explains how the White House found out about Ms. Lerner's emails. It says this, and I quote, "In April of this year, Treasury's Office of General Counsel informed the White House Counsel's Office that it appeared Ms. Lerner's custodial email account contained very few emails prior to April 2011, and that the IRS was investigating the issue and, if necessary, would explore alternate means to locate additional emails." So the Treasury told the White House in April, which would have been a month before you started at the White House. Is that right?
That's what that letter says. I wasn't there, so I don't know.
Ms. O'Connor, I want to thank you very much for being here today. I know this is difficult, but are you a lawyer?
I am.
You know what a hostile witness is?
I do.
You do? And the chairman told you that you were a hostile witness, and you said you were not. Is that right?
That's correct.
Do you consider yourself a hostile witness?
I'm definitely not hostile.
So you got a subpoena last night, a unilateral subpoena, no committee vote, no debate at all, nothing. And then you had to turn around and testify here this morning. And so I want to state for the record that we've seen no evidence that Ms. O'Connor did anything inappropriate whatsoever, and we want to thank you for your service and for your testimony. Mr. Ferriero, let me turn to you. The challenges at IRS are not unique. Many Federal agencies have had problems retaining electronic records. I know the President has made some improvement with his memorandum in 2011, and that you and the Office of Management and Budget have set target dates for agencies to improve their electronic data systems. But we can always do better, can't we?
We sure can.
As you know, I introduced the Electronic Message Preservation Act a year and a half ago. This bill would amend the Federal Records Act to require you to establish minimum standards for Federal agencies to manage and preserve email records electronically. The bill would complement your efforts to get agencies to modernize their record-keeping systems. This bill passed our committee with bipartisan support, I'm very pleased to say. You have testified several times in support of the legislation. Do you think the legislation could help improve the quality of the Federal email preservation?
I certainly do. And in fact, the directive relied heavily upon the language of EMPA as we were crafting the directive.
I sat here last night. I think we were here at 10:10, and I listened to the testimony. And this goes to you, Mr. Webster. And I'm trying to figure out how do we. It seems as if when it seems like our system at IRS and probably other agencies we're so far behind the IT modern world. How do we get a hold of that and move forward? I mean, because it sounds like that was part of the problem here. Ms. Ferriero? Oh.
And that's what we address in the directive. I agree with you that we have a lot of work to do in the Federal Government, working with our CIO partners.
Is it too big to solve?
No, it's not. It's not too big. We've created something within the National Archives, this capstone project, which is one solution that takes advantage of existing technologies. The biggest problem over time, and this is in the paper environment as well as in the electronic environment, is whenever you have a human being in the middle of it making decisions, then you have problems. And our focus has been on getting the human being out of the process and relying on technology to capture the information that we need to capture.
My last question, what can we do? I can see us sitting here, but I probably won't be here, but in 5 years, 10 years from now, sitting here going through the same situation. What can we do as members of Congress during our watch to help address this issue? I mean, you said people. Well, we got to have people, so we can't let everybody go. So what do we do?
Well, we have the directive, and we're moving ahead. So we have the support of the administration for this, and we have the EMPA bill, If you could convince your colleagues to get that, the EMPA bill passed and get it through the Senate, that would also help us, because that would legislate the change in the Federal Records Act that we need. The Federal Records Act today says print and save. This is 2014, and we're printing and saving? This is embarrassing.
Thank you very much. Thank you, Mr. Chairman, for your indulgence.
Thank you. I just want to make sure I make the record clear on something the ranking member said. I checked with Congressman Gowdy, who has a lot more knowledge of law and prosecutor than I do, and he said that a term I should have used was non-cooperative witness rather than hostile, since you in the White House refused to provide your services here on an ordinary request, and we had to subpoena unilaterally based on a denial that you would appear otherwise. So I want to make sure that I don't use a word that perhaps does make people think something that isn't true. This is simply a witness that refused to cooperate without a subpoena. Mr. Mica.
Well, thank you, Mr. Chairman. And just for the record, I heard the ranking member start with the comments that we were hauling people up here unnecessarily. That was his phrase. And I would take a great difference with that comment. First of all, last night we brought Mr. Koskinen back, the Commissioner, and we brought him back, and I went through his testimony when he came to us in March, and he never mentioned any problem with the emails back in March, Lois Lerner's emails. The Chairman showed everyone on the committee, both sides of the aisle, asking for Lois Lerner's emails. He came and said to us that last week, this is his testimony in March, last week we informed this committee and others that we believe we completed production of all of the requests under the Inspector General's report of May 2013. And he, in fact, testified last night in his written testimony that he'd been aware of technical problems back in February. So I think we had every right to call him back. The other side would intimate that this is some kind of Republican stirring things up. My goodness, last week, the entire country and the Congress was stunned to find out that 27 months of Lois Lerner's emails had supposedly been destroyed or her computer crashed. So I think we have every right. Mr. Archivist, the law says that Federal Records Law requires that the National Archives be noticed when documents are destroyed or lost. Is that the law, sir?
That is the law.
Okay. And Ms. Connor, you were brought on board after this report. This is not a Republican report. This report was prepared by the Treasurer Inspector General for Tax Administration to see if groups were targeted, and it confirmed that. Are you aware of this report, Ms. Connor?
I have read the report.
Okay. And you were brought on to what? To compile the records from and all the information pertaining to what was in that report, or?
I was brought on to give advice to.
Well, we had
Commissioner Werfel on a
requested
number
in
of
May
things.
certain documents. When you came on in early June, the IRS sent documentation retention notices to employees who were identified as having documents, including relevant email, potentially relevant information to investigators. You were part of that request and notice to employees in early June. You were there in early June?
I was there in early June, but my understanding is that a subset of employees
Well, this had been
already
sent
received
out, but
a
you're
notice.
aware that that request had been made to employees to preserve and present documents.
Absolutely, it's an
Yeah,
important.
that was your
important
job.
notice.
So
Yes.
it's appropriate that you're both here today. When did you first learn that there were emails missing?
I learned that Ms. Lerner's emails were missing as the result of a computer crash the week before last.
So you were in charge from May until November of compiling information from Congress, and you never heard before that there was any missing documentation as far as emails?
I didn't hear that any of Ms. Lerner's emails were missing.
Now, when you were compiling this information for the 4 committees of Congress and working with Mr. Werfel, who did you report to?
Mr. Werfel.
Okay. And were you aware that he was reporting your activity and what was being found? You were in charge of compiling the information, reporting to Mr. Werfel, right? Did you interact at all with anyone at the White House?
Not when I was
Between May and November when you were there. If I get your emails, your schedule, like Shulman, who was
I cannot
Shulman
recall ever
was
having
before
any
that. He came and
conversation with
testified
anyone
to us
at the White House.
that the only time he went to the White House was for egg rolling, and then we subpoenaed the White House records, finding he went there 113 times or something like that. But you had no contact with the White House during that period?
Actually, you're jogging my memory, and I actually want to use that as a footnote to just say that I'm doing this completely by the fly off of my memory because
but there was there some contact? Because now
yes,
you
I'm going to tell you what it is.
Yeah, and now you wind up in the White House. You had a subsequent job, I guess, helping with the Obamacare situation.
Could I answer that question?
Yes, go right ahead.
I feel like it's something important to finish the sentence. Mr. Werfel went to the White House in, I think, late June with Secretary Lew in order to give the President his report. And I went into the White House with him. I wasn't in their meeting.
Was this matter discussed at all?
I wasn't in the meeting. I just accompanied
You weren't?
him to the building.
Okay, so
That's
we
my
would
one
find that
contact
record.
with the
No
White
other contact in the White House during that period?
No.
But you're aware, would you be aware that your activities were being reported to Mr. Werfel? Then usually they have the counsel or someone that might have been Treasury reporting to the White House as to what was going on. Say with this report, you're not aware of what took place there?
So in terms of the IG report, I have no idea what, if anything, was reported to the White House. The visit that I had with Mr. Werfel was to give his 30-day report to the President.
No, but again, what your activity was reported to Werfel, where you were in the investigation and compiling for Congress, you weren't aware of it being transmitted beyond him?
No.
Okay,
Thank you. We now go to the gentlelady from New York, Ms. Maloney.
Thank you. I regret I was not able to join you last night for the hearing. We had a Financial Services Committee, or rather a bill on the floor that I had been working on, and we were in debate on the floor. But I just wanted to make a brief statement about the hearing that we had last night on the overall IRS, and this whole IRS mess seems to flow directly from confusion over just how the IRS should enforce a law that was passed by this Congress that gives tax-exempt status to not-for-profits, but only if they are essentially politically nonpartisan. And what the IRS was looking at is whether these activities of these not-for-profits really merited being tax-exempt because they're getting 100% deduction and putting a great deal of money into political campaigns. Now, we don't have—
Would the gentlelady yield?
Okay.
You probably were not here when this was discussed, but 501c4s do not get 100% deduction. You are not tax deductible on your donations to 501c4s.
At all?
Not at all, not a penny.
Not a penny.
They are tax exempt in that the money they receive from taxpayers who have paid their taxes and then give them their after-tax income, they don't count it as profit. They simply spend it on their behalf, but they are not tax deductible the way a charity is, and it's a very significant difference, and it is one of the reasons that they can do up to half of their activities in these. These are social welfare groups, not charities.
But they're social welfare groups and they don't get a tax deduction?
When you give to a 501c4, you do so without a tax deduction. It is taxable, and then you give your after-tax. It's exactly the same kind of tax deduction you get when you receive a political campaign. Your donors pay their taxes and then give you after-tax income. It is not a charity.
Not at all. Well,
Not at all.
I stand corrected. I thought 501c4s had a tax treatment that was favorable to them. And I was saying, why not just have a rule that no one gets a tax deduction that gets involved in political activities? But I think getting back to the emails, when 22 million emails from the Bush White House went missing in 2003 and 2005, which was only discovered under the Valerie Plame affair, our colleagues across the aisle had a different take on how things should happen. And were there any provisions put in place after this loss of emails between 2003 and 2005 that made it less likely that emails could go missing again? I ask anyone who would like to answer that. After there was a terrible debacle in 2003 and 2005, what changes were put in place to prevent this from happening again?
So I would suggest that that's an example of some of the challenges that all Federal agencies across the government have as it relates to managing email. And the instance that we're talking about today with the IRS is also another, where agencies need to be able to understand how their email systems work, how their email systems work in connection with the Federal Records Act, and how they're ensuring that preservation is occurring according to disposition schedules. So that's been a wake-up call for the entire Federal government.
Well, I would also say that a wake-up call is that you need your infrastructure to be high-tech and in place. And Mr. Farrow, as you may be aware, the IRS has a $1 billion IT infrastructure, but the Federal Times recently reported that sequestration and other cuts have imposed terrible restrictions on the IRS, including a reduction in the agency's supplies and materials and budgets. And can you, and so you basically have an antiquated IT system in addition to not putting reforms in place. So can you discuss how maintaining an antiquated IT system might impact an agency's records retention capability? What does this mean, these budget cuts and not having an updated IT system?
It certainly plays a role in this particular case in terms of the capacity of their hard drives to retain information, the number of emails that they're actually able to capture at one time. The upside of the directive that we're in the process of implementing is that it gives us the authority to work with the industry, the electronic mail industry, the high-tech industry, to create solutions that will work for the Federal government, efficient, effective, and cost-benefit solutions to this problem. So I'm optimistic about the future.
Well, has funding been a significant challenge to some of these agencies in modernizing their IT records and retention infrastructure? The Commissioner testified, and I read his testimony, the IA has proposed $400 to $500 million of modernization and improvement activities, but this has not become a reality in the budget. Others have complained that the Department still has not completed the switch from Microsoft Windows XP to Windows 7. What kind of problem is that? Can you elaborate a little further?
This is a problem across the government in terms of the investment in technology.
Okay.
Would my colleague yield?
Absolutely.
At last night's hearing, it was established that the IRS has had over $800 million worth of cuts in its budget in the last 4 years and is slated for an additional $350 million this year. You can't have it both ways. You can't be cutting the IRS that kind of amount and then decry the fact that they've got antiquated IT systems. I thank my colleague for yielding.
Well, my time has expired. Thank you.
I thank the gentlelady, and I thank the gentleman for pointing out the 10,000 less workers, but not, in fact, a smaller IT budget.
But I know the Chairman shares my concern about the IT investment.
You know, I really do, and I wish you had stayed longer last night to hear the accolades from both sides of the dais for the IG and his independence, his nonpartisan, the TIGDA's efforts, and how much he's relied on as a nonpartisan. I think it would have been very, very insightful.
You know, Mr. Chairman, I appreciate that. My wife is ill, and I have had to go home at night to be
certainly have our sympathies.
I know that he would appreciate that.
Thank you. The gentleman from Ohio, Mr. Jordan, is recognized.
Thank the Chairman. Ms. O'Connor, in the 6 months you were at the Internal Revenue Service, who was the person in charge of getting the documents that Congress wanted to this committee and to the Ways and Means Committee?
I guess I would say that that's Mr. Werfel, because he directed the agency at the time and told us what his directives were to.
But in the people who were working on document production, who's in charge?
So I served, as I think I was describing, as sort of a liaison between him and the team.
So it was you?
A big team of
Was it you? Were you the person in charge?
I wasn't working on it full-time because I had a number of other responsibilities.
Well, when we interviewed Mr. Wilkins, who is the chief counsel at the IRS, he said it was you. He said employees who have been responsible for collecting and producing documents, we asked him who's responsible for that process, and he said it is Tom Kane and Jennifer are the two I identify as the key supervisors. And then he said, Ms. O'Connor, and he said yes. So he identified you as the chief person. So in the 6 months you're there, this is a huge story. You got the key player in this who took the fifth. It's in the news every day, and in that time you're telling us you did not have any inclination that a bunch of Lois Lerner's emails were lost.
I did not know that her emails were missing and unrecoverable and that there had been a laptop crash that had caused that.
Okay.
I didn't know
Okay. So when you did learn, what was the date that the White House counsel's office learned? Mr. Koskinen told us last night he felt he had no duty to disclose, that he knew in February that there was a problem. He knew in March that there were lost emails. He didn't tell us at the end of March, but he did, well, someone at the White House learned in April. We didn't learn until June when they sent us a letter just a week and a half ago. So when did the White House counsel's office learn that there were lost emails?
So I just got there.
I understand, but I'm asking when the council. I mean, how big is it? There's only like 25 lawyers in the whole.
I wasn't there in April. I have seen the same letter that you've seen, and it, describes their.
So do you know the date?
I don't.
Is it fair to say April? I mean, that's what your boss, Mr. Eggleston, said. He said it was sometime in April when they learned from the Treasury. Is that accurate?
I have no reason to doubt that it's true. I just wasn't there. So.
Okay. And then do you know who from Treasury told the White House counsel's office that emails were lost? Do you know who that person was?
I don't know.
You don't know who was in that meeting, or if it was a meeting, or if it was a phone call, or how was it communicated?
I'd love to be helpful. I just started, so I'm unable to answer your question. I just wasn't there yet.
And do you know if anyone in the White House counsel, once they got that information, did they tell anybody else? Did your boss, the White House counsel's office, did they tell the chief of staff at the White House? Did they tell the president? Who was that communicated to?
Again, I'm sorry. I don't mean to be broken record, but I wasn't there.
You didn't talk. I mean, we asked you to come to this hearing a week ago. So in the week you didn't ask, like, what happened here? We learned in April. The Congress didn't learn until June. You didn't ask any of your colleagues in that. How many lawyers are in the White House counsel's office? Approximately 25.
I'm sufficiently new that I have not done a head count. I honestly.
My understanding is around 25 lawyers. You'd think maybe you would talk to those folks and get the details about what you're going to come to this committee and have to answer questions about. You didn't do that?
So the letter that I received from Chairman Issa said that the reason that you wanted to talk to me was to understand what I learned at my time at the IRS. I obviously did not have much time to prepare, but I prepared to come and tell you.
But you didn't even think to ask about the fact that the White House knew in April and the People's House doesn't know until June? You didn't think there was a duty to figure out, who gave you the information, who you may have shared that information with? I mean, it seems like everyone knows this stuff except the Congress, and we don't get it for months later.
So again, what I'd like to be able to do is be as helpful as I can with what I knew when I was
Well,
at the IRS.
it would have been helpful if you had those answers to those questions. Do you know if the White House counsel's office, once they got this information that, in fact, Lois Lerner's emails in a critical 2-year time frame were lost, do you know if the White House counsel's office told the FBI and told the Justice Department?
So what I can tell you is what I knew when I was at the IRS.
No, I'm talking about now. You work at the White House counsel's office. They knew this information in April. We didn't know it till June. There's a 2-month time difference there. In that time, did the White House counsel's office tell the FBI? I mean, remember what the President said. He said he's angry about this. People have to pay. This is outrageous. There's no place for this. This is all the things he said when this scandal broke. So I'm wondering if you get important information like Lois Lerner's emails are lost, did you share that with the agency doing the criminal investigation? You say, hey, this is serious. We better get this information to the FBI and to the Justice Department. Did you guys do that?
I'm happy to answer questions about my time at the IRS. I was there.
I'm asking, did your boss, did the folks you work for at the White House counsel's office, when they got this critical information, did they share it with the Justice Department?
Mr. Eggleston actually started the same day that I did, so our tenures are the same.
He's the one who wrote the letter to Dave Camp saying they learned of it in April from the Treasury's chief counsel. When he got that important information, did he get it to the folks who were running the criminal investigation? That's important. Or do you think there's no duty for the White House when they got critical information? There's no duty, no obligation to share that with the Justice Department who's running a criminal investigation? You don't think they have to do that?
So
they can just sit on the information?
I see
the gentleman's time has expired. You may
Can I
answer.
answer the question? I'm happy to work with you and with your staff to try to get you information as we can to answer your questions about my time
Mr. Chairman, if I could, that wasn't the question. The question was, do you think the White House counsel's office has a duty to share critical information about lost emails with the Justice Department when you knew that 2 months ago?
Okay. I think the question is now understood. Can you answer that question, please?
And my
Can
answer
she not
would
be interrupted?
My answer would be that I'm here as a witness about the facts that I learned at the IRS. To the extent you have questions about activity at the White House, I'm happy to work with you and see what we can do to get you answers. That's not what I'm prepared to talk about today.
Actually, from the Chair, I need to advise, when a question is asked and you're an attorney and he's asking if you have an opinion as to whether or not knowledge of a crime should be referred or the knowledge of something you think is a crime should be referred, it really is a yes or no, or I do not feel.
I'm happy to answer that.
Please.
I think knowledge of a crime should be referred to the FBI, yes.
Thank you very much, and I thank you. And the next is the patient gentlelady from Illinois, Ms. Duckworth.
Thank you, Mr. Chairman. Ms. O'Connor, has it been determined that the crashed hard drive was a crime?
Not as far as I know.
Thank you. So when the White House, well, let's go back. Last night, Commissioner Kruskin testified that he found out about the crashed hard drive in April of this year. Were you working at the White House at that time?
I was not.
When did you start at the White House?
Just about a month ago.
About a month ago. So middle of May?
Yes.
Middle of May. Okay. So you would you have any information in the prior to the middle of May or in April? Would the White House have called you and told you that they received information or did not receive information from the IRS before you started working there?
Nobody called me from the White House to tell me they'd received information from the IRS.
So you would not have known?
No.
The current commissioner testified that he only learned in April that the crash had happened and that in that process they were still trying to recover some of the lost emails. And in fact, they have managed to recover some of the emails that were lost because they, even though they were crashed and lost from the from account, Ms. Lerner's account, they were actually found in the 2 accounts of the 82 custodial accounts of the people that received the emails, and they were sort of going through that process. It's by no means complete, but they were going through the process. Again, this happened in April. Would you have had any knowledge of that?
I didn't have any knowledge of that in April. I do think that the measures that they described that they went through sound exhaustive and appropriate.
But let's go back to the 5 months you worked at the IRS. My colleague indicated that there had been previous testimony you were identified as the person in charge of the employees whose job it was to produce the documents that had been requested by the various committees. Did you write the evaluations for all of those employees?
None of them directly reported to me. My role was as an advisor, and I did my best to help them and advise them and work with them and work with the committees and essentially make sure that the team that was working day to day, all day long, to do this all night long, I mean, they worked very, very long hours, knew what the priorities were for which employees' material was going to be produced, what the search terms were supposed to be. Many of the investigating committees, including this one, had specific requests. Please get me the BOLO spreadsheets, or please get me the training materials, or whatnot. And I tried to facilitate that and help the team figure out how to prioritize what reviewers were looking at, what materials so that it could move quickly, those kinds of things. So I played a role, but I didn't write any performance evaluations because none of them directly reported to me.
Okay, so you played an advisory role, but you had no direct responsibilities in terms of evaluating them, direct them exactly how they should go about doing the data gathering. You simply advised them as they were going through the process, and then your job was to report back to Mr. Werfel on the progress of the effort. Is that correct?
I don't want to leave the impression I didn't work closely with them. I did. It's
okay.
just I was not their direct supervisor.
Okay, thank you. Mr. Ferriero, I just would like to get a little bit more into, I'm really interested in the capstone process, and I want to make sure we give that enough of attention. One of the things that really astounded me last night was when I learned that only records that IRS employees determine relevant would be printed out, and then those would be archived. But it was up to the individual employees to decide what would be and what would not be. I'm looking at the National Archives and Record Administration Bulletin 2013-02, titled Guidance on a New Approach to Managing Email Records, which talks about Capstone. And Mr. Chairman, I'd like to have this entered into the record, if possible.
Without objection, so ordered.
Thank you. In point 8, it actually says, talks about pre-accessioning policy, that talks about how pre-accessioning, if that were to be conducted, would mean that you would actually assume physical custody of copy of all the records, usually well before it is time to assume legal custody. Can you sort of describe that process and how that would interact with individual employees, or whether that takes them out of the picture?
I will take that.
Oh, okay. I'm sorry. Thank you, Mr. Wester.
So with the pre-accessioning policy, what we want to do is offer agencies the opportunity to transfer physical custody of email records to us so that we can ensure their preservation at the National Archives, so that they are not, in any kind of danger or anything in an agency. So this is a way to ensure adequate preservation of archival records, those 2 to 3% of records that agencies create that have permanent value that would come to the National Archives. We'd bring them in through that pre-accessioning policy and maintain them physically, and then at the time of transfer, which may be in 15 or 20 or 30 years after that date of their creation, then make them available through the National Archives access programs.
So once you have it, then those IRS employees, for example, or whatever agency it is, couldn't actually go and delete the copy that you have, correct?
No, they would be entrusted to the National Archives itself. They would be in our physical custody, even though they would still be in the legal custody of the IRS.
Well, that would be useful. My time's up, Mr. Chairman. You're back.
Thank you. I'd ask unanimous consent that the press release from the Treasury Inspector General for Tax Administration, TIGTA, dated November 21st, 2013, be placed in the record without objection, so ordered. It's entitled, Increased Oversight is Needed of the Internal Revenue Service's Information Technology Hardware Maintenance Contract, and it goes into the tens of millions of dollars that were spent in 2012 fiscal year on maintenance that was neither needed nor was it performed. We now go to the gentleman from Michigan, Mr. Walberg.
Thank you, Mr. Chairman. Mr. Ferriero, just to review a bit, in your testimony, you state that when agencies become aware of unauthorized destruction of Federal records, that they are required to report the incidents to the archives. At any time in 2011, through last Monday, did the IRS report any loss of records related to Lois Lerner?
No.
Is it fair to say that the IRS broke the Federal Records Act?
They're required, any agency is required to notify us when they realize they have a problem that could be destruction or disposal, unauthorized disposal.
But they didn't do that.
That's right.
Did they break the law?
I'm not a lawyer.
Well, you administer the Federal Records Act.
I do.
If they didn't follow it, can we safely assume they broke the law?
They did not follow the law.
Mr. Walberg, I think you've got a witness who's smart enough to know that he knows he would have liked those records. He'd like to have gotten those records. He was entitled to those records, but he'll let the lawyers argue out the law.
Let the lawyers argue out. The general American public, who wouldn't get away with that if they were before the IRS themselves, and said that they didn't report a specific page or a specific document. I mean, that's the frustration. And I hope those that are watching understand we're dealing with a law here that was broken by an agency that has the power to tax, which is also the power to destroy. Mr. Ferriero, in general, I guess could you briefly describe for us the print and file record-keeping process and how it works?
I would like to take that question for you.
First of all, I need to apologize about intimating that the Federal Records Act itself says print and file.
So the Federal Records Act, as the archivist has said, does not stipulate that you have to print and file, but it is a practical activity that most agencies have adopted as part of their policy, so as to ensure that Federal records as defined in the Federal Records Act are identified and put into official record-keeping systems within agencies. The connection to the Federal Records Act is that it is based on an analog and paper model for managing records, and as a practical matter, most agencies, if not all agencies across the government, have had print and file policies where individual employees are required to identify what the Federal records are and put them into the record-keeping copy within their agency for retention according to records control schedules that the Archivist of the United States approves. What we are trying to do with the capstone policy and the activities with the Directive on Managing Government Records is to automate this process so that we can eliminate the human intervention and the likelihood or the possibility of humans making errors and us and agencies losing control of records. So print and file has a long history of human intervention, whether it's printing it on paper and putting it into a file folder or clicking and dragging an electronic file into an electronic file folder.
But the IRS they have that policy?
Their official policy, as we understand it, is the print and file.
In general, do you think it would be sufficient for the Federal Records Act for an employee to save emails that are Federal records to a local folder on their computer's hard drive instead of printing those emails out?
It's inconsistent with the guidance that the IRS has given to their employees, and their official guidance is to print and file email records, in this case, to paper, and put them in the official record-keeping system.
If an employee were to deliberately not comply with the FRA by not printing out their emails, would they be subject to any sanctions under the FRA? If so, what sanctions?
I am also not a lawyer, but it's not an enforcement statute. What we do with agencies when these sorts of issues arise is have them report to us what has occurred in the instance where emails or other kinds of records have been alienated or destroyed, and then what are their plans for reconstructing those records or putting plans in place to make sure that this sort of activity does not happen again in the future.
Let me just complete the questioning here. If a Federal employee's hard drive crashes with no warning and no backup of the email exists, do you believe it's proper for an agency to assume that no records were lost?
No.
That's the question. The $100 billion question that, Mr. Chairman, we hope we ultimately can get an answer to. I yield back.
I thank the gentleman. The Chair would now recognize the gentleman from Nevada, Mr. Horsford.
Thank you, Mr. Chairman. Last night, the actual chairman, Chairman Issa, took an extreme action by issuing a unilateral subpoena to the White House. He demanded that Ms. O'Connor show up here today within 24 hours and under threat of contempt. There was no vote on this subpoena. The committee did not debate it. Members did not have the opportunity to weigh the gravity of what the chairman did in the committee's name. Now we find out how misguided that subpoena really was. Ms. O'Connor, let me just confirm what we've heard here this morning. You were not at the IRS when employees were using inappropriate search terms. Is that correct?
I was not at the IRS during the period covered by the Inspector General's report.
You joined the IRS after the Inspector General issued his report. Is that correct?
Yes, I joined on May 30th, 2013.
And you left the IRS in 2013, which was long before the IRS made these recent discoveries this spring about Ms. Lerner's email. Is that correct?
That's correct, yes.
And you joined the White House less than a month ago?
About a month ago.
And according to a letter we received from the White House, that was after the Treasury Department informed the White House in April about potential problems with Ms. Lerner's email. Is that right?
Right. I've seen that letter, and it refers to an April referral or informing in April, yes.
Thank you. Thank you. I quite honestly do not understand how Chairman Issa was able to rush to issue this subpoena, to force you, Ms. O'Connor, to be here today within 24-hour notice. Your connection to this topic of today's hearing is at best a stretch, and all of these questions could have been answered by simply picking up the telephone and asking. It's just a continuation of the same charade that, unfortunately, this Chairman continues to use this committee to perpetuate. And what's further insulting about this is that the Chairman promised to use the authority of this committee responsibly. Let me read what the Chairman said back in 2011, and I quote, "I'm going to take the thoughts on why you object seriously. To be honest, I will ask other members of my committee, am I doing the right thing? I will also undoubtedly talk to other members on your side and say, am I nuts? Am I wrong? Is this somehow a subpoena that is outside the mainstream? So I don't intend on simply writing subpoenas endlessly." But that's exactly what Chairman Issa has done. Since he became Chairman 4 years ago, he has issued more than 50 unilateral subpoenas. He has never once allowed a debate, and he has never allowed a vote. Not only do these actions contradict the promises that he made 4 years ago as the Chairman, but they result in unwarranted and abusive subpoenas like the one he issued last night. Now, many constituents do care about the issue of the wrongdoing that occurred at the IRS. And there are members on the other side of the aisle who I have listened to try to understand the concerns about the lack of accountability of those individuals who should be held responsible. But unfortunately, that is not what the Chairman has allowed us to focus on in any of the hearings that we've had dealing with this matter. In fact, he's used this process to politicize the process and to not focus on the proper oversight or government reform function of the committee. But perhaps this should not be a surprise, because during an interview on August 19, 2010, before Chairman Issa became committee, he was asked what he planned to do with the ability to issue subpoenas, and his response was, and I quote, "Cabinet officers, assistant secretaries, directors, I will be able to take on everybody that the President hires and relies upon." Well, he has certainly made good on that promise. I yield back my time.
Thank the gentleman from Nevada. The Chair would now recognize the gentleman from Arizona, Dr. Gozar.
Thank you, Mr. Chairman. You know, the ranking member brings up new legislation about electronic preservation. Mr. Fierro, that's pretty much immaterial if you don't uphold the rule of law, right?
Well, the hope is that you—
Well, the hope is, but I mean, if you don't uphold the rule of law, you can pass all the legislation you want to. It doesn't make a hill of beans about it, right?
That's true.
How about you, Ms. O'Connor? Would you agree with that statement?
The importance of upholding the rule of law, it's very important.
I want to read former Supreme Court Justice Brandeis made a comment. In a government of laws, the existence of the government will be imperiled if it fails to observe the law scrupulously. If government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself and invents anarchy. So a civil society's importance of following the rule of law is very important. Would you agree, Ms. O'Connor?
Absolutely.
Yeah. Mr. Fierro, you found out about the potential loss of documentation by the IRS or through a letter to the Senators Wyden and Hatch?
Through that letter in June.
You are aware that Federal Regulations 36 CFR Part 1230.14 states the agencies must report promptly any unlawful or accidental removal, defacing, alteration, or destruction of records in the custody of that agency to the National Archives Records Administration Modern Records Programs. True?
True.
Yeah. That's what I thought. So once again, we got a problem. Last night I cited, the articles of impeachment for the attorney or for President Richard Nixon. Actually cited the inference about the IRS. People are scared of the IRS because the power to tax is the power to destroy. Wouldn't you agree, Mr. Fierro?
I know that people are afraid of the IRS, yes.
Yeah. missing documents kind of similar to missing tape minutes. Wouldn't you agree, Mr. Fiaro?
I'm not sure they equate.
Whoa, 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 whoa. Missing material, missing material, missing records, the same. Agreed?
Missing material.
Yeah. And then we haven't followed the rule of law, so everybody is scared to death that there's one application to bureaucrats and there's another application to the regular lay people on the street. You know, it defies me. Ms. O'Connor, I mean, you've been in the Clinton White House. You used help with the Clinton administration with the Teamster union strike. In fact, you've been quoted as being a veteran of Washington battles. Would you agree with that?
I've been here a long time.
So you know the process, right?
I'm not sure which process you're referring to.
The bureaucratic inside the Beltway politics process. You know about these record keeping and aspect of that as well.
I'm not a record-keeping expert. Certainly, I have.
But you're an attorney. You have to know that when there's a problem and you don't have records, or there's a problem with records, you know to report it, right?
I know that if you discover that records have been lost and they're not recoverable, it needs to be reported, yes.
Let's go back through this again. The accidental removal, defacing, alteration, or destruction of records in the custody. So it's not just loss, it's potential problems with it. So in your tenure over at the IRS, there was no inferences, Ms. O'Connor, that there was some sequencing problems or some problems with the emails out of Ms. Lerner's office? None.
Nobody raised to me what I understand to be the issue that arose here, which is an identification that some of the emails were.
I didn't ask about missing, and that there were some problems with her email, because even the commissioner said that it was known that there was problems with that, with her records.
I don't recall knowing that there were problems.
So no one reported to you that there was any problems?
I don't recall anybody telling me that there were problems with it.
Would you consider the conduct of Ms. Lerner normal?
Which conduct?
The conduct in front of this committee and her conduct in front of, supplying a question to the audience, seating a question to the audience. I mean, as an employee and somebody supervising records and looking at it, would you say the conduct of Ms. Lerner is being normal?
Well, just to break it out, the question at the conference it wouldn't be something I would advise. In terms of the laptop situation, my understanding from the material that's become public in the last week or so is that she took quite a number of efforts to have the laptop reconstructed, and that seems to be appropriate.
Very good. You could also look at it from the standpoint of America looking at it is covering up for a crime, too.
I have no evidence that that's.
Well, if you're from the inside out, I mean, it's pretty interesting that you could actually try to cover that up in regards to the way that you look like you're coming off on disclosure. Let me ask you one last question. So the way she took the fifth, is that normal, Ms. O'Connor?
I don't have any point of reference for that.
You've seen plenty of taking the fifth, have you not?
I have not.
You have not. Okay. I yield back.
Thank the gentleman from Arizona. The Chair would now recognize the gentlelady from Illinois, Ms. Kelly.
Thank you, Mr. Chair. Mr. Ferriero, the National Archives and Records Administration is required by law to ensure the investigation of all allegations of unauthorized disposal of Federal records. Is that correct?
We don't actually do investigations, but we are charged with ensuring that we follow up on any reports that we have and urge the agencies to conduct such an investigation, yes.
So you just said you don't investigate the allegations yourself, but you do instruct the entity to conduct on their own and report back. Okay. During the Bush administration from 2001 to 2008, the National Archives reported that they opened 92 cases into whether agencies improperly disposed Federal records. Does that sound correct?
I believe
it does.
Okay. If you do the math, that was a little more than 11 years ago, or almost one per month. Is it fair to say that such allegations are relatively common?
You have the data.
Yeah. The allegations are common. I would suggest that it's not unique to administrations, but it's reflective of the challenges that all Federal agencies have with this issue.
Okay. On June 17th, the National Archives and Record Administration sent a letter to the IRS chief in the Office of Records and Information Management indicating that the loss of some of Ms. learners' emails may constitute an unauthorized disposal of Federal records. Is that correct?
That is correct.
Do you think that records retention is a problem exclusive to the IRS?
No.
A 2008 Government Accountability Office investigation found evidence that several Federal agencies, including the Department of Homeland Security and the Department of Housing and Urban Development, omitted at least one requirement of National Archives regulations related to proper management of electronic records. It certainly appears that Federal agencies across administrations have struggled with records retention. What is the NRA role in developing a long-term solution to this problem that will endure even after this administration is over?
Let me start with just describing the state as has been self-identified. Over the past 4 years, we have been working with each of the agencies to develop a self-assessment of where they stand in terms of their control over especially electronic records. And the data shows that a high percentage of the agencies self-report that they are at high risk. So that's why we have created the directive and are moving ahead to create the solutions to those problems.
And what can agencies do to mitigate this longstanding problem? What ideas?
There are a number of ideas, most of which are captured within the Managing Government Records Directive. As we've talked about earlier, agencies need to identify ways to automate these processes to take the human intervention out of the activity, because that is where the highest risk for error to occur or other things to occur that that do not ensure good record keeping. So to the extent that we're able to have industry days and identify private sector vendors and get their ideas about how this auto-categorization and automation can take place with email and other electronic records, and then identify what the minimum electronic records management requirements are that the National Archives needs to promulgate to the vendor community and also to Federal agencies so that they can better manage this electronic content. Those are some of the things that we're working on so that we're able to meet those deadlines within the directive.
Because it would seem as though as our technologies continue to improve, the amount of information that agencies must manage and appropriately store increases. So how important is it for agencies to make improvements to information systems to ensure full compatibility with new technologies?
It's very important. They need to think about this in several kind of sectors. One is the policy piece, which the National Archives is most responsible for, in getting that piece organized so that they're thinking more creatively and differently about how to manage records in automated sorts of ways with our support. Also thinking about the technology issues, working with the vendor community and the private sector to understand how automation can be added in cost-effective ways to make this happen, and then identify ways that agencies can, in a fiscally responsible kind of way, add this technology and implement these policy changes so that agencies are managing their records to meet their business needs, protect the rights and interests of the government, and then from the National Archives perspective, make sure that we're able to get the permanently valuable records into the National Archives so we can make them available to future generations.
And there are a couple of other aspects of this directive that we haven't touched on that are very important. The directive calls for the appointment of identification of a senior agency official, not the records manager, but senior agency official who takes responsibility for records management within that agency, raises the profile of records management in the agency. At the same time, we're working with the Office of Personnel Management to create, for the first time in our government, the job family records manager. There's no such thing right now in the records management environment. So we have a variety of credentials that are in operation now across the Federal government.
Thank you. My time's up. I yield back.
Thank the gentlelady from Illinois. The Chair will now recognize the gentleman from Tennessee, Dr. Desjarlais.
Thank you, Mr. Chairman. Ms. O'Connor, I just wanted to ask you a few questions. What was the reason you were hired in May of 2013 to join the IRS?
So Mr. Werfel called me the day after he started and said that he had undertaken this significant challenge and was trying to add a few extra people to help him, a chief of staff, a risk officer, and a counselor. And our project was to help him as needed in various ways to run the IRS, which at that point was facing new leadership and had the problems that I know your committee knows about.
Okay. Your Chief Counsel, William Wilkins, testified before this committee that you were a key supervisor of the IRS's document review and production process. Would you think Mr. Wilkins was correct?
I don't quibble with what he said, but as I was trying to explain earlier, I wasn't working on that full-time. There was a large number of people who were working very hard full-time, but I worked with them to try to help them.
In your time at the IRS from May 2013 to November, did you coordinate the IRS's response to congressional requests for documents?
I worked with the staff of the committees to make sure I understood what they needed. I was certainly a part of the process of making sure that what they were asking for was delivered to them.
Did you review emails related to IRS targeting?
So the review process involved an enormous number of people who were in sort of tiers.
Okay. Did you review emails?
I wasn't in the, set of employees who were doing the first-level review or the second-level review, that sort of thing.
Did you redact emails related to the IRS targeting?
I didn't do any redacting, no.
None at all?
No.
Okay. Did you determine the schedule of making document production to the committee?
The schedule was basically as quickly as we can, and
so you did
it was
do that?
determined by the calendar.
Okay. So you did make the schedule?
It was determined by the calendar. Basically, we looked at how quickly we could amass
Who decided when the IRS would make a document production? I mean, who specifically?
Well, it really was the calendar. I mean,
Okay.
the effort was to do it as quickly as could be when there was enough to produce.
Did you interact with the Treasury Department while at the IRS?
Yes.
Okay. How?
How? Telephone call, in person.
Okay. What did you discuss with the Treasury Department?
It was a variety of things. The IRS obviously is part of the Treasury Department. Mr. Werfel reported to Secretary Lew, and there were a variety of different things at any meeting.
So did you update them about the response to the congressional investigation and targeting?
I did provide updates when we were going to produce documents that we would be doing it, and things like how many documents were in it and that kind of thing, yes.
Okay. Did you interact with the White House while at the IRS?
I didn't. As I explained earlier, I had the one interaction where I went with Mr. Werfel as he presented his 30-day report to the President. Other than that,
so just one time?
I didn't have communications with the White House about my IRS work when I was at the IRS.
Who was your point of contact at the White House?
For what?
When you were interacting with them? You said you interacted
I didn't have one.
You didn't have a point of contact, okay. When you joined the IRS, were you given training on preserving Federal documents or Federal records?
There was an enormous amount of training right in the onboarding, and I think it did include records management, but there was so much it's actually hard for me to remember now.
So it included preserving emails?
I think so.
Federal records. Who provided the training for you?
I think it was computer-based.
Okay. Did you back up your emails or official records while at the IRS?
I think that my computer, because I was in the counsel's office, was being backed up. And when I left, my records were all copied by the IT staff in the counsel's office.
Okay. Were you ever aware of an attempt not to preserve IRS records by any IRS employee while you were there?
No, I'm not aware of that.
And do you know, did you store your emails on your hard drive?
I don't know.
Okay. You know what the size of your email box was?
I don't know.
Okay. That's fair enough. I have no further questions.
Thanks.
Chairman, thank you. I would just like to point out that the Speaker of this House today admonished all of us that we need to show respect to all the witnesses who come before us. In fact, he said, we invite people to come and provide testimony, and frankly, they should be treated with respect. And I believe respect includes asking a question and then allowing a witness to fully answer the question and not cutting them off. So I'm hopeful that as this hearing and other hearings move forward, we will continue to show respect as the Speaker of the House has recommended to us. Let me ask Ms. O'Connor a question or two. Chairman Issa issued a report entitled, "How Politics Led the IRS to Target Conservative Tax-Exempt Applicants for Their Political Beliefs." The report alleged that the President's political rhetoric, quote unquote, is what, quote, led the Internal Revenue Service's targeting of tax-exempt applicants. Ms. O'Connor, did you see any evidence that IRS employees were motivated by politics or political bias in screening applicants for tax-exempt status?
So as I said earlier, I joined the effort after it started at the end of May, and I left midstream at the end of November. And so I didn't see all the documents that were produced even while I was there, and more continued to be produced after I left, and I didn't talk to witnesses. All that said, I didn't see any evidence of that, no.
Are you part of a government-wide conspiracy to target President Obama's political enemies?
Absolutely not.
Are you here voluntarily and not a hostile witness?
I'm not hostile. I did receive a subpoena.
Would you have come had you not received a subpoena last night?
Well, the initial response that we gave pointed out that I didn't have a lot of relevant information because I had only been at the IRS for the 6 months, and it was after Ms. Lerner's material was collected, and it was before the discovery of that she had emails that were not recoverable connected to a computer failure. So I think the initial reaction was that there would be many better witnesses to assist the committee.
All right. Now, Mr. Fierro, for a long period of time, the IRS did not back up their records. And in fact, it was incumbent on each of the employees to print a copy of any email that they thought was relevant for historical perspective, which is alarming in and of itself. It's also pretty alarming that they are still using Windows XP, which was first used in 2001, and Microsoft does not even support that anymore. So I think for every American who pays taxes, there's a great sense of insecurity in not knowing that any communication they have with the IRS may, in fact, be lost. And if there is one agency that we want to have comprehensive backup, it would be the IRS. Is that correct?
I agree, but I also can testify that this issue about outdated technology exists in many agencies across the government.
All right, so this is a problem we should be looking. Maybe this committee could undertake something that was constructive in nature and look at all of these agencies and whether or not there is sufficient backup of documentation. As I understand it, when Mr. Werfel came to the agency back in May of 2013, he made a decision implemented IRS-wide that would require that there would be a daily backup of its email servers. Is that correct?
Do you know that? I don't know that.
So you don't know that. Do you know that, Ms. O'Connor?
He did.
He did. So now we can have confidence in knowing that at the end of every day, there is a backup. All emails that have transpired during the day are backed up within the IRS. Is that correct?
That was my understanding when I was there.
All right. So my only question is, on the one hand, last night the Commissioner said we have had all these cutbacks and we need more money to be spent to be able to have the kinds of servers necessary to retain all this information. Mr. Werfel did take steps to back up everything. Are we at a point where everything is backed up, or do we still need more technology? And Mr. Fierro, maybe you can answer that.
Actually, the point I'd like to make about that is that having a backup system in place is not a record-keeping system, and that's, I think, part of the discussion about what kinds of technologies do agencies need to have effective electronic record-keeping. The actions that have been described that the IRS has taken meet the needs of being able to produce emails and other electronic records for inquiries from committees like this one, but it does not deal with the electronic record-keeping issues that agencies need to deal with around disposition and preservation and access for business needs within agencies necessarily.
All right. Mr. Chairman, I know my time has expired, but I just wanted to point out on behalf of our colleague, Ms. Maloney, that her point was that 501c3s and 501c4s are tax exempt, not that the donors' contributions necessarily are tax exempt, but that the 501c3s and c4s are tax exempt for purposes of collection of taxes.
Well, you know, I appreciate your pointing that out. I think the point, and I received a text from the Ways and Means who thanked us for helping point that out because it was one of their frustrations over that committee. The fact is that corporations in America, if they take in, let's just say that they're providing a computer service, if they take in $1 million and they spend $1 million doing support and they have nothing left over at the end, they also pay no taxes.
That's correct.
So a 501c4 who takes in $1 million from people who want to have it do some service and spends it all pays no taxes. So the difference is a 501c3, people may give $1 million and avoid nearly $500,000 in personal taxes. So the difference in scrutiny for a 501c3's activities, not being political because political contributions are not tax deductible, the 501c4s follow the same rules as your PAC.
Except that my PAC has to disclose who makes donations to me,
and the 501c4 does not. And I truly appreciate that. The fact is that Congress, in its wisdom, has not legislated that disclosure. We did not put it under the Federal Election Commission, a place where Lois Lerner worked for many years. We did not empower that. So the President's OFA does not have to disclose. That's just simply the law as it is. I just wanted to make sure, and I think Ms. Loney was very surprised, that people do not get a tax write-off for giving to 501c4s. Therefore, the term tax exempt doesn't have the meaning that most people think it has when they lump together charities, 501c3s. And it is extremely important. The American Heart Association, the American Cancer Association cannot engage in 49% of its activities in favor of promoting candidates because it's a charity. And there is a huge difference, and it's a difference I think the Ways and Means is sensitive to, because legislating changes is serious business. 501c4s, in fact, do not enjoy that, just as your homeowners association doesn't.
Except that 501c4s are supposed to be exclusively for social welfare purposes.
I appreciate that, but the court standing is majority. I now recognize Mr. Cummings for unanimous consent.
Thank you very much, Mr. Chairman. I want to ask the Chairman to admit into the record a letter dated June 23, 2014 from the White House, Neil Eccleston and counsel to the President. This is a follow-up on what was just
the letter from the White House will be placed in the record without objection.
To explain, Ms. O'Connor, what Mr. O'Connor was saying with regard to hostile witness. Just explain it, just as you explain yours.
Non-cooperative witness, they refused to provide her.
Mr. Chairman.
He has been informative. I appreciate that.
You admitted it.
It's in the record.
Thank you.
The gentleman from Texas is recognized. Oh, would the gentleman yield me 10 seconds?
Certainly.
I just want to put it in perspective for Mr. Webster, and if you agree, you can answer on the gentleman's time. If we continue to collect data the way they're describing, what you're doing is effectively taking all the data at the end of 6 months and throwing it in a trash heap. And then the difference, if you just collect a bunch of tapes, is the equivalent of owning the yard that your trash is hauled to and saying it's all there. If I understand correctly, what you're trying to achieve with Capstone, Mr. Ferriero, is, in fact, to have the meaningful data retained so that it's searchable and usable, while recognizing that the vast majority of data is likely not to be of any value, and certainly you would not want to search through it to find the important data that is effectively being thrown out today.
Yes.
Thank you. Thank you, Ms. Farenthold.
Thank you. Ms. O'Connor, I want to follow up on some questions Dr. Desjarlais asked. He mentioned, and you said you'd gone through extensive training with the IRS on their document retention records policy, and that you felt like your laptop was probably automatically backed up. But the actual document retention policy doesn't have to do with backup or saving files. It has to do with printing out things that you believe fall under the Records Act. How many in your tenure at the IRS, do you have an idea how many things you printed out to keep for the archives?
I have no volume, but just to get back to I just want to make sure it was clear what I said. I went through extensive computer-based training. I don't think that much of it was on records retention. All that said, I
did you print out any to save?
Oh, absolutely. And
would it be more than 1 or 2 a day?
I don't have a recollection, but what I explained is that what happened with my electronic material when I left is that the IT people in the Chief Counsel's office collected that and then copied it. They made a copy of it, and my paper records were all transferred so that they could continue to be used by my successor. And
so when you printed them out, was there just like an inbox type thing on your desk? You stuck them in. What did you do with them after you printed them out?
I had files in my office.
Was it one big file, or was it broken up under files, based on subject matter, or do you recall how that was done?
It was in different categories. I can't really remember.
Okay. I guess what I'm getting at is I'm trying to imagine the amount of work necessary to go in and recover, say something from Ms. Lerner, and then the amount of work that eventually goes in when those documents get to the National Archives for sorting them out.
I don't have a good point of reference.
Mr. Fiorina, let's talk about the records. I mean, assuming you got your capstone project, had you rather have more records or less records?
I'd rather have the right records. And the identification, the work that goes on between the records manager in the agency and my records management staff is the creation of schedules.
But you don't always know what's going to be an important record at the time you get the email. I mean, if there was an email about what parking place somebody is going to get assigned, that probably isn't an important record until maybe, God forbid, an employee comes in with a car bomb and parks in that parking place. All of a sudden it becomes relevant. So trusting an individual at the time it's happening to decide what's a Federal record, it probably is not a very good way to do it.
I agree, and that's why the capstone takes that part of the process completely out. It captures everything for the senior executives of the agency.
So what's the cost of implementing it? I mean, does it work just like something that plugs into the network and captures the email? I mean, that in a broad general term?
So in general, when agencies look to deploy a capstone sort of solution to manage their email, they're usually doing it in the context of upgrading their email system. So at the National Archives in the past couple of years, we've transitioned email systems, and part of what we've done is rolled out this capstone technology implementation along with the policy.
And so you've got it. It's off the shelf. If somebody wants it, they can buy it for their agency.
It's not quite that simple, but it's COTS products that then have to be integrated by the IT shop.
So again, I used to work in IT, and I mean, is it as simple as plugging in a server and loading some software and making sure you have enough storage space on it? I mean, is there much more to it? I mean, obviously configuration and such, but I can't believe it was, IRS Commissioner testified $10 million to put in a solution like that last night. Is that an accurate number?
I don't know if it's an accurate number or not, but what I would say is that as agencies are moving to the cloud and as they're trying to identify solutions that can make capstone work, it's not a free activity. There are costs associated with doing integration and other sorts of things.
But certainly saving it digitally is a lot cheaper than printing something out when industry standards say each page you print out costs between 5 and 8 cents. It's got to be a massive savings over that.
There are probably massive savings with moving to electronic record keeping. Then also it's much easier to provide access electronically than having to provide boxes on carts in research rooms as we do today.
All right. I see my time has expired.
I thank the gentleman. We now go to the gentleman from Missouri, Mr. Clay. I've been saying,
I'm in shock, Mr. Chairman, but thank you anyway.
Oh, wait a second, Ms. Norton. I apologize.
It's Ms. Norton.
They said Clay, but you have returned, and I am thrilled to see the delegate from the District of Columbia, Ms. Norton.
Thank you very much, Mr. Chairman. I just thought you were looking through me. We have been asking about backups here, and by the way, the last member, my friend from Texas, was indicated, and I couldn't agree more, about electronic backup as opposed to paper. Of course, it costs money to do hardware and to get those things in. And so when you already have the old-fashioned stuff, you go with the more costly old-fashioned stuff. And that's been the story of the IRS and of many of our federal agencies, because it takes money to do things like that. It takes money to save money. Before I go any further, we've been talking about federal records of the kind, of course, that Congress would subpoena. Those are not the records that the average American would be most concerned about. The federal records they'd be most concerned about, for example, are their own taxpayer documents. Could I ask if there is backup for taxpayer documents, when you file your income taxes, for example? Mr. Webster?
I do not know the answer to that question. That would be most appropriately brought up with the IRS.
Mr. Fierro?
I agree that that's an IRS question.
If the gentlelady would yield.
I'd be pleased to yield.
We earlier had an oversight of IBM's role in the subcontracts to Mr. Casilio and so on. At that time, I became aware that, yes, the electronic data for filing of taxpayer records, which is the vast majority of filing today, which is far greater and far more vast than these emails we're discussing, does have a system and a backup, and it is a big part, a significant part of the $1.8 billion spent on IT. That's actually one of the interesting points of this is the small back end of the IRS compared to their massive spending in that database.
Mr. Chairman, could I ask you, at the same time, did we discover at that time whether there's backup for the health care data that's coming into the IRS, since these witnesses apparently don't have that?
My confidence is high that it does exist in that data trove, but that came in after our investigation. But it is a significant part, hundreds of millions of dollars of the IRS's new budget go forward is the maintenance of those transactions.
I just wanted, and as the Chairman says, this is kind of the back end, and this doesn't come up very often. It's very important. And let me say, because there's been a lot of back and forth and